Any mention?
Yes.
My lord, item number 50, 50 from the hearing days, my lord. Again, my lord, this matter pertains to the pending matter, the issue which is pending before the division bench, my lord.
Item
A
50.
relationship, yes, my lord.
This criminal petition 50 of 2024.
Yes, Lordship.
Yes, my lord.
Yes.
I'm for this.
Well, 3 weeks, my lord, father, let's see what.
Yes. 3 weeks. This.
My lord, oblige.
May it please, my lords, I beg to mention item number 41.
Yes.
Lordship, I pray for another 2 weeks.
No objection, Lordship.
Prayer made on behalf of the petitioner, not objected to the by learning council. Please, 2 weeks.
2 weeks, my lord. Grateful.
Yes.
May it please your lordship, I beg to mention item number 48. Your lordship, 4 weeks time may be granted as the matter is still pending before division bench.
Okay. This also 4 weeks. Yes.
My lord, I beg to mention item number 47. The senior counsel is on legs in another courtroom, so the court can kindly accommodate us for 2 weeks.
Inform me, madam.
47 also. The request of the petitioner. This after 2 weeks. Yes.
Triple.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 61, Your Lordship. Wait for 2 weeks' time, Your Lordship, this matter.
Lordship, I'm for respond number 2 and 3.
Any objection? No objection.
No objection. For this too.
And for the performer, defendant 4, 5, and 6, Your Lordship.
Yes, also 2 weeks. The request of the petitioner. Yes.
Oblige, Your Lordship.
Your Lordship, I beg to mention item number 40. Praying for 2 weeks' time, Lordship.
Who is the other side? Item 40. Item 40, 40.
Yes.
Yes. Yes, Mr.
My
Hajar.
lord,
Similar prayer
yes,
for
in
item-
that case, my lord, case record supposed to be produced by the district council advocate, my lord. Last occasion hearing is almost finished, that time they are. So next week, then, my lord. Supposed to produce this case record, they have produced.
Yes,
or not.
yes, sir. This was hard.
Yes, my lord, hard in detail regarding this Nokma, my lord,
Yes,
they are.
yes. It came to High Court several times. And
Yes, 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 yes. My lord. That is the case, my lord.
You are making a mention on behalf of
On behalf of as Mr. GHDC, Lordship.
HL Garo Hills. Okay, yes, sir. The request made on behalf of the rest of the number sign, sir. Not object to the learning council of the petition. List of 2 weeks. Yes.
Yes.
Similar prayer for item number 42, Lordship.
Yes. Who is there for petitioner?
I'm for the petitioner.
Yes.
No objection.
Same order.
Lordship.
May I please, Your Lordship? Your Lordship, beg to mention item number 44, Your Lordship. I'm praying if Your Lordship can have this matter after 2 weeks, Your Lordship.
My lord, I'm for respondent corporation here, my lord. I have no objection, my lord.
For the second level, right? It's
3 to 6, my lord.
the prayer of the petitioner, not object to the respondent. List after 2 weeks. Okay. Yes.
Lordship, I beg to mention item number 46, Lordship. Lordship, this is that section 482 application, Lordship. Here, Lordship, your Lordship has on the last occasion indicated that charge sheet in respect of the other matter will be required, Lordship. So, Lordship, I'm bring 1 week's time, Lordship. We have applied for the same, Lordship. However, now we have not got the same, Lordship.
Yes.
Yes.
46 also? 2 weeks at the request of the petition. Yes.
Grateful.
Lordship, joint prayer for item number 37, Lordship.
Item number?
37, Lordship. If Lordship, the matter can be taken up next week, Lordship. Today we have some difficulty, Lordship. 37. This is that central subsidy, Lordship, matter, which Lordship has heard.
Joint prayer, Lordship. Lordship, it's a joint prayer.
John Prayer made with the parties. List after 2 weeks. Yes.
I know it.
Item number 1.
Please, Your Lordship. I beg to mention item number 45, Your Lordship.
Oh, item. This is, you're too late for mentioning.
I'm just here. I'm sorry, Your Lordship.
Yes.
I beg to mention item number 45, Your
Yes.
Lordship. I pray for 2 weeks' time, Your Lordship.
45, 2 weeks. You are for the petitioner?
Yes, Your Lordship.
The request of the petitioner. Yes. Yes, item.
Lord, I have received the copy of the affidavit filed by this council. I'm paying for 2 weeks' time to file my rejoinder.
Lord, this is for admission hearing because there's a slight urgency in these matters because every month, because of these employees, the council has to incur additional expenditure of nearly over 10 lakhs. And if your Lordship will just have a look at my affidavit.
Please, Your Lordship, I have not received a copy of the counter affidavit.
No. Therefore, there's a separate case. Lord, we are talking about item number 1 first.
How many cases are there?
35 altogether. 35 cases.
And you have filed affidavit in all the cases?
We have filed in 34. Because 35 is a completely different issue, madam. Madam, just for 1 minute, I would like to draw Your Lordship's attention to my affidavit.
Yes.
Madam, we'll come to page 3.
Yes.
These are what the rule says, madam. Recruitment to all classes of service and staff shall be made after due advertisement and by competitive examination or the basis of an oral examination and interview. So the rules are very clear, madam. In all these cases.
See, there is no issue with that. The thing is that you have confirmed somebody in service. You have regularized. Now, even if you want to oust them from service on this ground, at least you should give them an opportunity.
Well, I will satisfy Your Lordship on that. If
That is what is needed.
I will satisfy my Lord on that point.
Anyway, let them file a rejoinder since you have filed the things.
Well,
Let
within
them
a
file
week.
rejoinder and then maybe we'll dispose it
Because
of
this
the
is
next week.
yes, because we want an early disposal, ma'am.
But then on the last occasion, you have taken time for filing affidavit.
Filing affidavit, yes, which we have done, madam.
This is item 34, Your Lordship. So it falls in that counter affidavit.
Item 30 we will pass a different order. First, let us
Yes.
pass in this order and then we'll see in this. Okay. This it is submitted to the learned senior counsel to the respondent that an affidavit in opposition has been filed in the matter. Stop. The learned counsel for the petitioner prays for grant of some time for filing a rejoinder.
Well,
Prayer, Lord.
Continue, Your Lordship.
Wait. List after 2 weeks. And then the main, in the miss case you just say, list along with the main case, the interim order past audience shall continue till the next day.
For admission hearing, madam. Let
This
it
will
come
come
up.
up for, this is already ordered for admission.
Well, admission.
This will come up for admission. And then, what about this 34?
34 we will be filing our affidavit.
So you have not filed an
We
affidavit.
have
How
not
much
filed.
time you need?
1 week.
Okay. 35 you just say. One prayer made by learned senior counsel appealing for the respondent. Further 1 week's time is granted for filing affidavit in opposition. Stop. We will come up with the next. This is
Let it come. Let it come up
This is
to that.
matter after. Another 2 weeks time is granted for filing affidavit. Okay. And then you just list accordingly, and then the miss case you just say same order. Okay. List along with the main case. Interim order past audience shall continue to that. Yes.
oh, Lordship.
36.
Yes.
Your Lordship, before starting this, I just take Your Lordship. There is, I got some this authority regarding this matters, that's to obtain the certificate copy, and this period is excluded. But I was not in a position to got printed, Your Lordship, due to my laptop has got
What is this matter about? You just tell us the fact. We do not know what you are saying. We do not.
Your Lordship,
That
this is the
certain
matter
thing.
of parting to the limitation, Your Lordship. Limitation.
This is what? This is an application for condonation of delay.
Condonation.
Yes, delay of how many days?
18 days, Your Lordship, according to me.
18 days for.
From the date of order. And if I consider this period of
Delay of filing a revision application.
yes, Your Lordship.
Revision against what order?
Against the order of the decisions.
In what matter? In a title suit or in a.
In a review petition.
In a
My Lord, in brief, my Lord, if I can explain.
Just please give the fact. Otherwise, this court will not know anything.
My Lord, there was a land acquisition proceeding, my Lord. That is LA case number 117 of 2015, my Lord. And one person by the name Ojendro Kharsandi.
This proceeding was under section 30.
This is a reference, under section 18, my Lord, old act. So
It is for enhancement.
yes, my Lord. So, my Lord, in that proceeding, one person by the name Sri Ojendra Kharsandi, he was the claimant in that proceeding, my Lord. And what happened during the pendency of the LA proceeding, my Lord, that said person, Ojendra Kharsandi, he expired. Thereafter, my Lord, the present petitioner herein, my Lord, they filed an application before the reference court that they are necessary party in the case and they want to implead.
For substitution or?
Yes, for substitution. They want to implead. They wanted to implead.
Substitution.
Yes. If you just correct us, what is wrong?
Yes. So they wanted to implead in that LA case, my Lord.
Not by your substitution.
By substitution / impleadment they have written.
Really?
So
what was the claim? Was it because of the death?
Now, my Lord, their claim is the petitioner, my Lord, their claim in that reference court before, my Lord, while they filed the impleadment application, they said that there was a title suit, my Lord, which was pertaining to the same plot of land which is under consideration by the reference court, whereby, my Lord, they said they have the case was decided in their favor, and then on death of Sri Ojendra Kharsandi, they wanted to implead themselves. Now, my Lord, the reference court has rejected their applications, my Lord, application for substitution and impleadment on technical flaw, my Lord, because only on technical ground that the application was rejected, and there.
What is the technical ground?
It is at page number 42, my Lord.
Page 42 of the revision application.
Yes, my Lord. If I can just take your Lordship to the operating part.
Yes, sir.
I'll just read from the page number 42, the last paragraph, my Lord.
No, this is a title suit. Page 44 is a title suit, order of title suit.
In LA case number 42, my Lord, page number 42.
Page 42, yes. Okay. Yes. Okay. Yes.
Order dated 12/7/2019.
Yes.
The last paragraph, my Lord, it says, Learned GP assails to the present substitution petition since no provision has been quoted by the applicant petitioner in the petition for substitution. Even in the affidavit, only one applicant, say so-and-so, has sworn the said affidavit, whereas the co-applicant petitioner has nowhere endorsed the said affidavit. Further, signature of the applicant petitioner needs to be clarified. Having heard both the rival counsel, this court makes the following observation. This court is unaware if it has any jurisdiction to entertain or hear this present substitution petition in as much as no provisions of law has been agitated by the petitioner applicant to invoke the power of this court. Without going into the issue of facts as contained in the present substitution petition, this court observes a number of technical flaws in the present petitions which, if condoned at this stage, will lead to a myriad of unnecessary conflicts of issue of law which will be fatal to the case of the parties thereupon at later stage. Upon the above observation, this court is not inclined to allow this present substitution petition. Petition is rejected and disposed of in view of inherent technical flaws, defects contained therein.
And then what happened to the LA proceeding?
Now,
Just a minute. He was a claimant, isn't it? Claimant died. There was an application filed for substitution, which
Right.
was rejected. Then what happened to the claim petition?
Claim petition?
That Lordship, that substitution petition, they filed, that is the implement and substitution.
That is all right. What happened after rejection of this? What is the status
After
of this?
after 210 days, they filed a review petition against that order. That revision.
Just a minute. You will come to that.
Yes, Lordship.
Just tell us what is the status of the, what happens if that after rejection of the substitution petition, what happened to that LA case?
LA proceeding, because claim
It stood averted.
No, there were other
no, Lordship.
Other counterclaim.
Last occasion they mentioned about that. That was not awaited, and it is continued. After receive, there is some other advocate.
It is continued in whose name?
TICMLA, because there are two claimants in the petition. One Ojendro Kharsanti, one Srimati TICMLA. Two claimants.
They had separate claim.
Separately.
So how could both of them be a party in one matter?
There can be claim and counterclaim.
Counterclaim.
LA proceeding.
That is section 30 then. Section 30 comes.
Yes, Lordship.
Section 8 cannot be in section 18.
Section 30.
Section 30.
Is section 30 petition.
See, they say us correctly. See, otherwise there will be a problem.
That is why I am stating about that, Lordship. That was the section 30 petition that the reference was made by the deputy collector. And then, Lordship, during pendency of the case, they filed application for substitution of implement. Initially, that party, they never mentioned about that, and that substitution petition was filed, Lordship, without following the provision of Order 22 rule.
Whatever it is, that is
no, because if the substitution.
Just give us the fact. Kindly come to know later.
This is the fact.
See, so after this rejection, they came up with another review application.
Review petition.
Seeking review.
Without
review of the order,
condemnation.
Order, my lord, review of the order dated 12/7/2019, whereby their application, my lord, of implement was rejected. So they wanted to review that order.
And that was barred by limitation.
Now, seldom there is a rejection in substitution application without an objection. Forget about technicals. The technicality should not defeat the main cause of justice. Now, why third party is here? What is your interest here?
The party.
How they are affected by substitution?
No, substitution not following due procedure of law, Lordship.
How you are affected? Just tell us. Who are you?
Because I am the one or claimant. I have been evicted by virtue
Are you claimant in this LA proceeding? Were you a party in LA proceeding?
Yes, Lordship.
How and as what? As a respondent?
Claimant.
Where is the LA case? Where is the?
Not on record.
Yes, they have not submitted anything.
How many claimants are there in that LA case?
Two.
If there is a reference under section 18, this reference was made on at whose instance?
It was named.
So it was not a reference under section 18.
This uncle, he was the party. My uncle Ujendra Kharsandi.
He was a party to what? It was a section 30 reference or section 18 reference?
In 18 reference.
In section 18 reference there is a contest from private party? How? You do not know your own case?
My lord, page number 41 of the. It says under section 30, my lord.
Yes.
Page number 41 of the.
The councils, they do not know. That is a problem.
Page number 41.
Yes. Under section 30 of the LA Act. Where is the petition? Where is the details? Where do you get the details? On what basis this section reference under section 30 was made?
No documents has been enclosed, my lord.
What is the amendment made in this petition?
Page 41, Lordship.
Page?
41.
That has been shown just now.
Yes, LA case number 117.
Yes, yes, we have seen that.
It was.
When this reference was made?
In 2015, Lordship.
Now, after the reference was made,
yes, Lordship,
definitely parties concerned.
Yes.
They have filed their respective claims.
Yes,
Isn't it?
Yes, Lordship.
Do you have copies of those claims here?
They have not submitted anything. Without any, they have suppressed material facts here. They have mentioned about one order of the title suit, but subsequent order was that order was set by this honorable court. That was not implemented.
1 second. You are an opposite party in that claim petition, isn't it? In section 30, in the reference, you are what?
Because in the petition I have seen that both the case I am the claimant. Reference
come to that page.
Subsequently I entered appearance.
Please come to page 29.
Lordship.
Page 29.
29.
Yes. You are TI assembly. Are you TI assembly?
I am TI assembly.
So you are an opposite party. You see what happens?
It is in miss case. That was a miss case.
It's all right. It's a miss case you have been shown. Miss case means that is substitution petition, not the review petition. This is an order passed in? What?
This 9/12.
This is 9/12/2024.
Yes, Lordship.
That is the latest order, which
yes,
is under challenge here.
That is reviewed.
Along with the main order.
Main order.
Now, that means you have been shown here as opposite party. Now, what is your status in the main claim petition? In the main case, in a reference under section 30.
Yes, they have.
Whether you are petitioner there or the opposite party?
I have been shown as claimant only first party in some papers. I have got it. Subsequently, Lordship, they are
give us the details. We will not know.
Because it is the duty of the petitioners to submit all the papers, Lordship.
The court should know the facts. If the petitioner doesn't know the facts,
because now today
you
it
give
is,
us the facts at least
yes,
to understand.
today it is fixed for only hearing on the that petition, Lordship, that condonation.
But then for considering
that is why, because it is a totally barred under section 3 of the Limitation Act. That is why the learned court below the debitor petition was dismissed. Earlier occasion, Lordship have stated about that it is a merge with the substitution order. It cannot be merged because the decision was taken not on merit. When the petition was barred by limitation under section 3, the court cannot go beyond that, Lordship.
You are going by something which is
it is necessary.
Right now, court is not on that issue. You see,
last occasion, Lordship asked me about that.
Maybe there may be passing observation. Okay, we will come to all those things later stage. First, let us the court understand the thing.
In their application, they have mentioned about the order dated.
We do not know if a person is seeking to be implemented, whether he wants to be a claimant there or the opposite party there. We do not know.
Yes.
If
in place of Ojendra Carson, they wanted to implement.
If she is the claimant, if she says that she has been shown as a claimant, then who are you?
And earlier, Lordship.
Perhaps you do not know your case.
So, Your Lordship, let me bring this all the news.
You do not know. You have come to High Court. You have filed a revision application seeking condonation. You do not know even the basic idea about what is happening in the trial. You know how the section 30 reference is made, and thereafter how the proceeding is instituted before a judicial, the special judicial officer.
Your Lordship, let me brought this by affidavit, Your Lordship.
How it is? How can he improve it?
These are the documents
You have to have understanding, otherwise it's difficult.
Your Lordship, I will
Now
bring
just
this
tell
record.
us in the list attached to the award, who was shown as the beneficiary of the compensation.
Lordship, in same plot of land, and one portion I have already received compensation.
So there is no objection in that part.
In that, at that time, they did not make any objection.
So the current one
Only
is,
105 square meter of land, they made objection.
do not just forget about the area of the area of those things right now. Just tell us this section 30 reference was made on what basis? Why? Whose name was there in the original list and who objected?
Claimant is my
My Lord, may I
petitioner.
page number 92. Yes. 92 of the, because this is their applications, my Lord, for implement. Filed by the petitioner, my Lord. Here, paragraph 2, my Lord, page number 92.
Wait, just a minute. Yes.
I'll just read out, my Lord, relevant portion. Paragraph 2, that the applicant petitioner are the legal owner of the land in dispute inherited by them from late Ojendra Kharsandi and late Srimati Hansa Kharsandi, that on the death of late Ojendra Kharsandi and late so-and-so, all properties left behind in their names devolved to the applicant petitioners, and the applicant petitioners are in possession and management of the same.
See, Mr. Singhan,
Yes, my Lord.
what this court wants to know is that, see, since there is no disclosure, the court is yet to ascertain who is the claimant and who is the opposite party. This court is asking these questions just to ascertain it. Now, in a land acquisition proceeding, when award is made,
My Lord.
the award is accompanied by a list of beneficiaries. That means who would be getting compensation.
My Lord.
Now, what happens if there is any objection to the payment
My Lord.
to a particular party by another person?
My Lord.
Then what happens? This objection is filed before the collector. And this is referred. And that is a reference to section 30.
Yes.
Now what happens in this reference? The objector becomes a claimant.
Right.
Okay. And the person name who is there in the list, he is the opposite party.
Right.
Then it becomes like a suit. Objector will go, will make his claim petition, and the opposite party will file their written statement. And that is where it starts. Now we want to know that is. You see, it seems the parties are not at all acquainted with anything.
My Lord. In the same case, my Lord, if my Lord will see.
And you are annoyed with the question of the
Right.
court.
Parties are mentioned, my Lord, if my Lord will just see in page number 92, same page, my Lord. Because this is the implement application, they have referred the party. First party is Srimati T.I. Simli versus Ojendra Kharsandi. So probably I was not, my Lord, I was not
So
counseled.
it means it is something like that. The private respondent's name was there in the claim list,
Right.
and they objected
Yes.
to 100%. That is probably this
It seems so.
initiation.
It will.
Yes?
That is
Correct. No, that is what. Now the court is getting now some bit understanding. So it means the substitution application which he has filed, it is insofar as the opposite party is concerned,
Opposite parties. Ojendra Kharsandi.
isn't it? Is it correct?
Yes, sir.
You are also going it because the court is saying it, you are saying it. What is your prayer in this thing, substitution application? You do not say you to be this thing implemented as what? You to be substituted as what? You have said here is implemented.
Prior it is given in the premises of it is therefore prayed that your Lordship may please to allow this instance applicant's petition for implement of the
Now
applicant
your
petitioner's-
application was rejected on technical ground. Okay, maybe rightly, maybe wrongly. Then you kept silent for some times, and then you filed a review application. Yes.
That too without
condonation.
Review
Without
after the lapse of the period of limitation.
Right. And they did not file with the condemnation petition, my Lord.
So review itself was not maintainable.
Not maintained.
So what is the order passed by the trial court?
Review application was rejected by the order dated 9/12/2024, my Lord. Page
But
number
by
27.
limitation.
Page number 27, my Lord.
Last line, 40. to 40.
Operating
Yes.
part, my lord, the last portion, small order, my lord.
No, this one. A to 40. 40, sir. A to main order. Page 40.
My lord, operating part is at page number 40, my lord. You. Paragraph 17.
I don't know.
Paragraph 17 says, my lord, the application for review filed by the petitioner at the very outset has not been filed in accordance with the provision of Order 47, Rule 3, CPC, read with Order 41, Rule 1, and 3A CPC, and is not accompanied by an application for continuation of delay. Therefore, on this count alone, without going into the merit of the review petition, the application is not maintainable, and view thereof, the review petition is hereby dismissed. So this was time barred, and again, when the petitioner.
So your petition was not competent. The review application was not in accordance with law. It was not maintainable in law.
So, Your Lordship, in this matter, my submission will be here, Your Lordship. In the land acquisition proceeding, Your Lordship, this limitation is not applicable. Your Lordship.
5 years.
You want to say in the land decision application, limitation act is not applicable?
Yes.
Show us some law. Give us some law.
In this matter, Your Lordship, some authority I was just.
Huh?
Some authority I have to produce it. That's why it needs some time.
You are saying it very confidently. There must be something. This court all along understood that in land acquisition proceeding, except for the part which is guided by the act itself, the CPC applies. Now you say limitation act is not applicable.
It is guided by the CPC only.
So once CPC comes, limitation also will come.
Yes, Lordship.
So the
Specific it is.
submission advice by Mr. Devnath is that in land acquisition matter,
Some citation is there.
Just show us something.
So
If that is the foundation of your case, otherwise
yes.
even your condemnation petition also
not maintainable.
Yeah, what is,
It
your
is a more
condemnation
than
is
5
18
years.
Days. 18 days. Which way you have calculated?
Huh?
What will happen to the period spent in that review application? And you have filed a petition under Section 5, isn't it? For condemnation. So there is nothing about exemption. What is that section? Yes, madam, what is that section 17, 15 Limitation Act? The exemption of period?
Exemption 12 is for exemption of period for the obtaining certified copy.
No, that
and
is
17 is different. For
17 says maybe exemption of period.
Yes, there is some guidelines of the Supreme Court also, Lordship.
Yes, no, but just we want to know the provision. Nothing else.
17 is their effect of fraud or mistake.
So 17 basically speaks about exemption. Now his case is under Section 5. It is condemnation.
Yes.
So we cannot go to 17 and all.
Yes, Lordship.
There is no question.
So, this condemnation application, my Lord, senior has filed for preferring this revision petition, because when he preferred this revision also, there was delay for filing this revision petition.
5 years, 9 months, 19 days.
Because the order of the review, order in review was passed in 9/12/2024, and is preferred 2025.
So that is beyond 90 days.
90 days.
So that calculation of 18 days.
And order of substitution.
Now just even keep it aside what you say about that filing of review application and all. Even if you calculate date from the date of the order of the review application, then also there is a delay more than 18 days.
More than 90 days.
Just let us see.
Lordship, can you look into the order of substitution? That is 12/7/19. That is the main order. He challenged
that is
in
what
both
your
the order.
contention is. That is what
that
your
is why,
contention is.
Lordship.
Now, say supposing, just tell us that the review order which has been challenged, can it be challenged in a revision or not?
Yes, because it is.
See whether.
Yes, Your Lordship, they can. Because it is there.
So if they can.
Yes, under 47 Rule 1,
Yes.
Order 47 Rule 7.
So at least this revision will be maintainable in so far as the order passed the review is.
Review only, not for that.
Well, give us some law on that. It seems to be very. You have some law on that. Do you have some law on that? that
No,
You have,
I
you
have,
have.
I have. Because all substitution order cannot be merged with that review order.
Before that, let us see what Mr. Singhon says about the. Yes, Mr. Singhon, what is the date of order of the review application? Date passed in the review application?
9/12/2024.
9/12/2024.
Right.
Yes. And when this revision is filed?
Revision
24/3/2025.
24/3/2025. Now revision period is 90 days.
90 days.
In between there is holiday. So
They
those is
will get
exempted.
that. The
So-
certified copies of order also.
Okay. So far as that 90 days is concerned from that period.
Yes, it is somehow made.
Okay.
But in case
So
of
that means what you say, Mr. Singhon, is not correct apparently.
not specifically mention about
No.
when he obtained certified copy, when he filed.
Anyway, then you'll do one thing. Then just we'll hear it on this.
Page 20.
Just show us the law that this period spent in that review application cannot be counted for this thing. Condemnation here.
Section 3 to
Otherwise, that very objection raised by them, that seems to be quite acceptable. So that is what you can argue. You argue the matter. Let us finish it now. It is good. Go the fact.
It is totally barred under Section 3.
Section 3 of the Limitation.
Yes, Limitation Act.
We'll do it.
Bar of limitation law.
Yes.
Judgment বিলাক আছে মোৰ লগত সব।
No, that is all right. That is a general thing. But then here they have come up with an application for seeking
Your
condemnation.
Without condonation delay.
Your Lordship,
They have not. They have
That is so far as the review is concerned. It's all right.
every appeal.
No, that is all right. That is
Appeal review any application.
That is all right. That is all right. You have understood that.
Your Lordship,
Okay.
Yes,
Right now, we are.
we have this petition 9/12/2024. So this page number 27, Your Lordship, if you can just come to this page number 27.
Order of the review. Order passed in the review.
Order passed by the district court. Your Lordship.
Another review petition to.
Your Lordship,
Page 27.
27.
Yes.
Annexure 1.
Yes.
Your Lordship, in this case, Your Lordship, order passed on 9/12/2024. And we apply for certificate copy 10/12/2024.
That is okay. So far as the 18 days is concerned,
So
I don't think they have no objection with regard to the 18 days. Their objection is with regard to the period spent in that review application. That you file a time-barred review. Okay. Your original order was passed on 12/7/2019. Is that correct? 12/7.
Yes, and both the order they have challenged in the revision petition.
Okay, and she says that doctrine of merger will not come because this is not a decision of merit. Now, so far as the order dated 12/7/2019 is concerned, whether the period of limitation will stand automatically extended just because you filed a review application, That too which was not maintainable in law. Say us something.
Yes. So, Your Lordship, in this matter, I'll have some. I'll take some time.
See, after giving so much of time, you should have said it in the beginning.
That's why before starting, Your Lordship, I just.
Lordship, in their petition, condemnation, when they have challenged both the order, 12/7/19 and 9/12/24 orders. Page 3.
What is the law in such a thing happens?
What about this?
What is the position of law?
Yes, it cannot be merged with the review order.
What is it?
Because the review order is not decided on merit. Oh, look.
Have you seen that order dated 14th 2017, which has been reflected in this order? 14/3/2017, passed in that land acquisition matter.
14/3.
Okay, see, there was an order passed in 14/2017.
On that day, probably Lordship will learn it
Yes,
below.
you see, this order is reflected there. Now it makes it more interesting.
Yes.
In fact, you see, it appears that the late Ojendro Kharchandi, isn't it?
Yes.
He died before that.
Long back.
Yes.
They have mentioned about long back.
He has not entered appearance at all before the learned special judicial officer. Instead, in his place, the Wakalatnama reflected name of Mestanath Kharchandi and Jestarul Kharchandi.
Yes.
And surprisingly, there was no substitution
Nothing else
on that
done.
thing. Okay, so thereafter, this court basically said the claim petition of the petitioner Mestanath Kharchandi and Jestarul Kharchandi cannot be taken on record unless they are made party either by substitution or by implement.
Yes.
So they are not even a party there.
Yes, Lordship.
No locus.
Yes.
Now this present petitioner is who?
That Mestanath Kharchandi, Jestarul Kharchandi and Mestro, they filed that petition.
Now this-
Implement substitution.
Okay.
That is on
that
20.
substitution was filed. Okay, this is Jestarul Kharchandi.
Yes, Lordship.
So you are not at all a petition. This
Yes,
thing.
Lordship.
They are made party either by substitution or by implement. So thereafter you file an application.
Yes, without any following provision of order 22 for substitution.
Where is that application for substitution, Mr.
এইটো আছে কিমানত ক'লে আপুনি
This page 92. You see.
They have not even submitted any death certificate.
Yes, definitely. We have to You have to see that.
Page 92.
কিমান মৰিছে এতিয়া লিমিটেশ্যনৰ কথাই নাই তাতে
Are you a party that suit before district council?
No, Lordship. I was not party. That order was set aside by this Honorable Court, Lordship.
Okay, but then even not a party, even that order stands
No,
also.
that order I have challenged before this Honorable Court.
Yes.
That was set aside subsequently, Lordship.
Okay. Otherwise also it would not bind you since you are not a
Yes,
party.
Lordship, I was not a party to that.
It
Well-
seems, Mr. Devnath, you have made a mess of this matter. This entire matter has been messed, and it's an example of mishandling of matter. This original objection was not raised by Ojendra Kharshandi. It was raised by the those who are seeking substitution here. And your grievance was that instead of showing your name as claimant, Ojendra Kharshandi was showed as a claimant. And that is why you wanted substitution. Was it the correct way to approve the court?
I suspect some fraud.
This is something seems to be very wrong.
Your Lordship, page 96, Your Lordship. Page 96, Your Lordship.
96. Yes.
This is the petition given to the before the.
See, we cannot go. We are going by your petition only. This court has found out whatever this court has stated right now. It has found out from your petition. Reading at page 93, paragraph 6 and 7 has made it clear.
Yes, Your Lordship.
Then.
So this is the information given to the deputy commissioner, because my uncle has expired.
So
in this place.
So getting it corrected, for the getting the name corrected, was it a proper procedure to adopt? There was no reference in your name.
Reference was not in my name, but my.
Definitely. So rightly or wrongly, it was a mistake by the collector at that point of time. He should have corrected it there.
In the suit also, Lordship, they did not make the lady as a party after knowing everything. I am claiming, and I got compensation for entire area that was suppressed by in the court.
Madam, a simple matter has been complicated. Just has been because it has been mishandled. It is totally.
Yes, Lordship. Also.
So you see, where is the question of condoning delay in these things? If it is wrongly handled, who can help it? And it is handled for quite a long time, right from 2017, or maybe before that.
13. Not suppression of material facts. Even in this petition, they did not mention about that setting aside of the judgment of title suit.
That also they have not said.
They never mentioned anything.
But then they contested it before High Court.
Yes.
Okay. Let us see. If there is something inherently wrong, we will impose cost. We are not these things. We can do that. We have the power to do that. Yes. Just say. Tell about your condonation. And just tell us which way we can ignore that period from the date of the original order.
So in this respect, I need some time. Your Lordship.
Now it's on you. You are coming from outside. There may not be
That
much
is
longer.
a different thing, but law is clear.
My Lord, Section 9 of the Limitation Act also, my Lord, is very clear, my Lord. It says continuous running of time. It says where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it.
This
It will
okay.
continuously run from the date when the earlier order, first order.
That is all right. This is all right. It may not be very relevant here so far as this thing is concerned. Here we are not. We are just concerned with this objection right by Ms. Dev. That period
My Lord.
which they spent in that review application.
Review application.
The review application was preferred admittedly after the period of limitation without any condemnation. Now, when a petition itself is not maintainable in law, in terms of Section 3 of the Limitation Act, whether period spent in that can be condoned.
Cannot be.
Is that correct? Is it
Yes,
what is-
Lordship.
Just by filing an application just to defeat or escape from some of the clutches of limitation, will it be allowed in law? Yes. What shall we do on the prayer of adjournment?
What I will do, Lordship, is matter already last occasion also I.
When we will give him another chance. When it will be all right for you? When shall we?
No more money. Application.
Yes, on prayer made by Mr. Devnath, seeking grant of some more time to prepare the matter. Comma, not objected by the Landed Council appearing for the respondent. Comma, the matter stands urgent. List after when?
After 2 weeks.
List after 2 weeks. See, Mr. Devnath, this is something, it's a mess.
I cannot improve also.
It is here only the person, those who handled, they are responsible for creating this mess. And even sometimes parties also suffer. And this is...
There is a commission of fraud, Lordship.
You said
Absolutely.
2015 this reference was made.
2013.
2013 reference.
Because prior to that, 2018, I
So
received
it means
compensation.
that person, what is his name?
Ojendro.
He died long back.
No.
No.
Jester Well and Mr. Nat Karsandi came before the Honorable Court.
No, when he died, this.
They're never mentioned. Never
That is okay,
mentioned
but then
anywhere.
Do you
Lordship.
have any idea?
We do not have it.
Whether it is before reference or after reference.
They have mentioned in their death petition, he died long back.
But then no date is mentioned.
Yes.
So it means a reference was made in the name of dead person. So it reference itself become invalid.
No, who appeared, Lordship?
The name of
Ojendro Karsandi.
SI.
That is what? Ojendro Kharsan.
Yes, both the
Reference was
parties.
made in the name of Ojendro Kharsan.
Oh, yes.
So it means if the person has died long back, so the reference was in the name of dead person, isn't it?
How? That is the
That is
surprising
what- so
fact.
That is where it should have been corrected. They allow the reference to be made in name of a dead person and then subsequently come and say. We do not know. And that say how much time they have spent. We do not know. You see, a person should always
I have been suffering
should
for
not be
that.
denied of a right to seek legal remedy.
That is
court should not
different.
do. We do not want to block them from
Yes,
raising
Lordship.
their grievance.
Yes, Lordship.
So-
But they cannot
But
go.
then the way this is handled, this is a problem. Even if they have any grievance, we do not know. This is what happens. Anyway,
It is bad. It is
Thank you.
totally bad, Lordship. Again, I am repeating
thank
that.
you. At least somehow court got the idea about them.
Yes, Lordship.
Thank you.
Obliged, Your Worship.
Hearing item 38.
Yes.
Yes, Your Lordship, in this case, for striking of application, we have taken
Made
steps.
this is Your Lordship. Lordship, there is an application for striking of Your Lordship. We are yet to file the. We need some more time, Your Lordship. We will file our objection to this application, Your Lord. That is application number 143 of 25.
Okay. You have to file objection.
Lordship.
What about the steps of notice upon respondent 5 to 10?
We have taken steps, Your Lordship. And as per the track consignment report, it says that it has been delivered, Your Lordship.
What does it say as per the thing?
Track consignment report.
What does it say?
It has been delivered.
So you have to file an this thing, affidavit then. Because here in the office note is not there.
Yes, Your Lordship.
Okay. Learning counsel for the petitioner submits the steps for service of. This will be in the miskis, huh? This is in the miskis.
Miskis 143, Your Lordship.
Step for service of notice upon the respondent number
143, sir.
5 to 10 has been taken. Stop. However, the office note indicates that report of service on the side respondent is still awaited. Stop. The applicant shall verify the status of service. Applicant shall verify the status and file a service affidavit in respect of the respondent number 5 to 10 within a period of
2 weeks, Your Lordship.
2 weeks. Just say, in the next paragraph you say, Mr. Shulai, ND Shulai, Honorary IG, appearing for the state respondent number 1 to 4, prays for grant of some more time for filing objection. Prayer relevant. Then you list after 2 weeks.
Let it be 2 weeks, Your Lordship, after 2 weeks.
And then the main case, in the main rate petition, 196, you just say list after 2 weeks. Just say list after 2 weeks. Yes.
Till 38, 39 connected.
39, Your Lordship, is connected, but there is no such application, Your Lordship.
Okay, so this will be just
Only
just on prayer made with the parties list of it.
Lordship. Apply, Your
Yes.
Lordship.
43.
Yes.
We have this matter, we have completed our argument.
When?
Because
How many months back? Have you given any written note?
I have given written argument. I have given.
Yes, on behalf of the respondents, before there is a written argument on behalf of the petitioner.
Yes.
Yes.
My lord, my limited submission, my lord, is that, my lord, initially, my lord, I was booked under section 468, 471, read with section 14 of the Foreigners Act, my lord. Now, my lord, learned trial court below, my lord, has acquitted me from the mischief of section 468 and 471, my lord. So what remains is section 14, my lord. Now, admittedly, my lord, section 14 of the Foreigners Act comes into play, my lord, if I overstay in the territory of India, my lord. At the point of time when I was arrested, it was the month of June 2012. And my visa was valid till the month of October 2012. Now, rightly, wrongly, my lord, there is some discrepancies observed by the learned trial court in the extension of my visa, my lord. But since I have been acquitted from 468 and 471, my lord, so where is the section 14 has got no legs to stand on its own, my lord. Because at that time when I was arrested, my lord, it was valid till October.
See, according to you, your passport stood extended.
My lord, yes.
But then according to them,
Yes.
it is forged.
Yes, my lord.
Now the charge of forgery against you has not been proved.
My lord.
So in such a case, you become a victim of the wrong.
My lord.
Isn't it?
My lord.
Your stay here is on the belief that your extension is valid.
My lord.
Isn't it?
My lord. So, my lord.
Now, it should have been a case where yourself you stand as a victim, not as an accused. Is it what you say?
Exactly, my lord, because state also did not.
Any law on that that if a person receives benefits of some forgery without knowing that you are receiving benefit forgery, what would be the application of law in respect of that person?
No, my
Whether
lord.
can wrong be attributed to him?
My lord. So far I understand, my lord. 468 pertains to, my lord, forgery, my lord. And 471 pertains to using the forged document as genuine, my lord. So I have been acquitted from that, even that I have not been using it.
Even 477.
Yes, my lord.
Can you give us a written note to your submission? Just in one page also, just give in.
My lord.
Just give your contention.
And my lord, in addition to that, my lord, now if it is a, my lord, case of section 14 violation, simpliciter, my lord, without any, my lord, 468 or 471 involvement. In that situation, my lord, even the practice of the government of India is, my lord, they give notice to leave the country, my lord. Some fine is also imposed, my lord. So, my lord, here is a case, my lord, now section 14 remains, my lord. So, my lord, I want to go
You
back.
have not been given any notice by them.
No, my lord.
Please, why don't you give a note of this?
My lord, my lord.
When can you do it?
Within a week time, my lord.
Anything you want to say? Or
Lordship, we are not going into that forgery part, Lordship.
no, see, one thing is what Mr. Gurung has correctly said. Even forget about 468 also. 471, you have acquitted him.
Yes.
So you did not find him using that 471 as genuine. So where the charge against him lies?
Now he has been convicted only under section 14. And for that, Lordship, I have given my reply in my...
If you say that as per for this thing, section 14 simpliciter, there is a provision of issuance of notice.
My lord.
Please quote that rule.
And that apart, my lord, there is even provision for exit visa also, my lord.
Okay. So kindly in your argument, please incorporate those.
My lord.
Because if we pass an order, then we will be needing
My lord.
things. And if possible, you can show the extract of that piece of
Within a week time, my lord.
Lordship, if we have chosen to overlook that forgery part, so we are only on section 14. So that section 14, I have given my reply in my written argument.
What do you say in your reply? Just in
written reply, this is from paragraph 2, Lordship, of my written reply.
Just tell us what.
Okay, written reply, this paragraph
Without
2 is
making us
just...
read.
I have,
Give us the gist of this. You do not have to give in detail.
paragraph 2, I have reproduced the section 14.
Yes.
And from paragraph 3, coming to the visa, Lordship, on examining the visa, the petitioner was permitted to stay in India up to 17/10/2011, which means the visa was valid up to 17/10/2011. After this date, the visa has expired. It is no longer valid. Thereafter, the petitioner obtained the so-called second extension of the visa after 1 year from the date of the first extension expired, that is 17/10/2011. The second extension of the visa was given on 15/10/2012, just one day before it expired on 16/10/2012. Assuming but not admitting that the visa extension is not forged, but the petitioner has overstayed in India exceeding the period of the first extension, which was valid up to 17/10/2011, for the reason that the second extension should have been done prior to the expiry of the first extension, which may be 1 week or 1 month ahead, but it was not done. But it was done after a long gap of almost 1 year.
Forced extension, it was done after lapse of the period of earlier period.
Yes.
There is a considerable gap.
1 year.
So that is where admittedly where he is.
So therefore, it is submitted that it is violative of Section 14 of Foreigners Act, and this amounts to overstaying of India in India exceeding the period of the visa for which the trial court has rightly convicted the petitioner under Section 14 of the Foreigners Act.
So even
This
Mr.
lordship.
Gurung, even if you say supposing, even if you say that your stay for that extended, alleged extended, the forced period is not illegal, what happens the lapse of time between your expiry of your genuine extension and the start of your alleged forced extension?
My lord, coming to that, my lord, at the last extension, my lord, the wording reads like this, my lord. Permitted to stay till on or before 16/10/2012, my lord. So meaning my submission is that, my lord, it covers my...
You do one thing, can give a written note.
My
Since he has given a written note,
My lord.
yes.
My lord, yes.
Lordship, I have completed my Lordship.
Okay.
Produced my written argument and
Yes,
past Mr. Hodala.
You do one thing.
I have replied to all the issues pointed out by my friend. Yeah, I have given my reply. So your Lordship may peruse my written argument.
Yes, just say. Parties have completed their oral argument. Stop. Mr. Khalil Landed, additional PP, has also submitted his written gist of argument. Stop. On prayer read by Mr. Argurum, Learned Counsel for the petitioners. 2 weeks time is granted for submission of his submission of written notes of his argument.
I have given a very short written argument.
That is what
Lordship.
we have said.
No,
Just
yes,
stop.
very short one.
Stop. We will stop. Then you say list accordingly. List accordingly. We will just wait for submission of this.
It looks lengthy, Lordship, because I have reproduced that section 14, the entire section 14.
Okay,
That's
okay,
why. Obliged, Lordship.
So that is the main point of controversy.
Yes,
Deeply
49.
Yes.
May it please your Lordship.
Yes.
Lordship, can you have the order dated 27/6/25? Lordship, so far the issue raised, the controversy as to whether the list, the notification dated 7/3/2000.
That is that signature in the gradation list.
Yes,
That is
Lordship,
the,
yes. Is Lordship, can you come the third paragraph here, Lordship? Third paragraph from the bottom.
Yes.
The learned counsel for the petition disagrees with the contention made by the respondent and submit that the notification is not a list prepared under so and so, Lordship, Rule 1975. That, Lordship, I take Lordship to the writ petition. Lordship, kindly come to paragraph 15.
but you are supporting instruction, is it?
Lordship, I'll place that, your Lordship.
You don't want to place it directly.
I'll place it, your Lordship.
You want to create the climax and thereafter.
Lordship, kindly have paragraph 15, your Lordship.
Of the writ petition. Just a minute. Mr. Shula, here you have to address this court so far as this.
Yes, your Lordship. I'm yet to. I have not opened my argument, your
Yes,
Lordship.
yes, that is it.
Lordship, only on that issue, your Lordship.
Yes.
Lordship, kindly have paragraph 15 at page 16, your Lordship. That the facts that the promotion conducted on Lordship. I'm sorry, your Lordship.
Yes, please.
Paragraph 15, your
Yes.
Lordship. That the fact that the promotion conducted on 7/3/22 and so appear to have been conducted under the provision of Rule 22 of the web. So it is their own admission, your Lordship.
Okay. So petition says one thing and then
Lordship,
submission is something else.
Lordship,
Otherwise, what is your
we
instruction?
cannot, Lordship, my humble submission, my humble prayer before your Lordship is that Lordship, litigant should not be allowed to blow
Is it
hot
the
and
case
cool,
that
your
they
Lordship.
have
Lordship,
they
yes.
say one thing in the petition and they argue
Lordship,
the entire.
Lordship, we cannot allow to blow hot and cool, your Lordship. Lordship, I do have the instruction, your Lordship. The instruction is very clear, your Lordship, is that there is directly from the minutes of the selection board meeting, your Lordship. That list of 7/3/2022 is derived directly from the minutes of the selection board meeting held for the purpose
So
of
that is in terms of that order
Lordship.
22.
This is
Rule
the
22.
written instruction, your Lordship. So in view of that admission, your Lordship, in paragraph 15, your Lordship, in my humble and respectful submission, your Lordship, writ petition, they have no case, your Lordship. The writ petition are liable to be dismissed, your Lordship.
My Lord, if I may.
Yes, yes.
My Lord, as per the last order, state was to get the instructions.
I have the instruction, your
Instructions are there.
Yes.
If I can request affidavit be filed, a short affidavit, placing on record the instructions, so that even I can respond to that, my Lord. Because apparently
See, your own statement is there.
apparently some list is there. I'll respond to that affidavit, my Lord. Let them put it on record.
Is there any list, separate list other than
That
this?
is the list, your Lordship. 7/3/2020.
What is the question of bringing it on record?
22, your Lordship. That is the list prepared on the basis of the minute of the selection board, your Lordship. And they have not challenged. They are happy with the list, your Lordship.
I'll respond to this. My Lord, the fact that selection board prepares a list is under the rules. But one, my Lord, with respect, I point this out, one has to be clear that list prepared by the selection board is a list in what respect, my Lord? If Lordship allows me to elaborate on this point, looking at Rule 22, or 23 rather.
Just a minute.
Yes, my Lord.
I have not made any note. There's no note of mine. This is not there. The note made by the court is missing.
My Lord.
Yes.
Well, if Lordship is kind enough to look at Rule 23.
Yes.
Prior to that, my lord, Rule 22(2), it contains the composition of the selection board, Chief Secretary, Commissioner of Division, 2 senior most secretaries. 23, my lord. I'll read this slowly, my lord. The seniority of members of the service promoted to the senior grade timescale shall be in the order in which their names are arranged by the selection board under sub-rule 2 of Rule 22 for the purpose of promotions to that grade. So, my lord, this is crucial. The seniority of the selection board arranges the names after maybe conducting interviews being conducted by chief secretary, etc. The names are arranged by the selection board. The names are arranged, my lord, as 23 specifies, for the purpose of promotion to that grade. So the names are not arranged to determine seniority in the service. The names are arranged, my lord, to determine seniority for the purpose of promotion to that grade. If I can explain a little more on this, elaborate a little more. My lord, taking an example, there are 10 persons who have been found eligible, my lord, to be promoted. Eligible on the basis of 22(1), ability, integrity, and character. The last portion, my lord, 22(1). So 10 persons have been found eligible. Their names are sent, my lord. The selection board, chief secretary, commissioner, etc., conduct interviews, examine the position, my lord. Then the selection board, my lord, finds that amongst the 10, there has to be a seniority. Selection board prepares its list as per seniority for promotion. So on the day the selection board issues that list, there may be 5 posts in the senior grade. So based on the selection board list, which the seniority in the selection board list which has been prepared for the purpose of promotion, 5 out of the 10 receive promotion today because there are 5 posts available in the senior grade. 1 month later, 5 more posts come up in the senior grade. Then the remaining 5 in that seniority list prepared by selection board receive promotion to the posts that have come up. So seniority. My seniority in the service is not determined by this, my lord. The seniority that this 23 speaks of is the seniority for the purpose of promotions to that grade. So on the day list is prepared, there are 2 posts available. The top 2 in that list will be promoted, so on and so forth, my lord, as and when posts open up, my lord, in the senior grade. So to say that seniority is fixed by the selection board, it is fixed, but one has to be clear, my lord. It is fixed for what purpose, my lord? For the purpose of promotions. So selection.
Right, but then the same list has to be followed. Whatever the list is prepared by the selection committee, that has to be followed.
No,
for the purpose of reckoning seniority.
My lord, with respect, I beg to differ, my lord, because what happens is, once I am promoted, the question of seniority will be determined by 16(4), my lord. If lordship kindly goes back to 16(4).
We cannot come back to that, Your Lordship. We cannot come back.
If I can finish my submissions.
We cannot come back to that, Your Lordship, because that issue has already been determined.
So I'll just finish my submissions. 16(4) says, the seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared under so-and-so, the merit list, my lord. So, selection board prepares the list, no doubt. There would be a list, no doubt. There would be some sort of seniority in that list, no doubt. But that seniority is only for the purpose of promotion. My seniority in the cadre, in the service, will not be dependent on the selection board list. It will be dependent on my position in the gradation list. That gradation list, my lord, has to be prepared on the basis of 16(4), my lord. So,
see, so far as a 16(4),
yes, my lord,
everything stands determined by the earlier round of litigation. Now you just say about the cause of action which arose after that.
My lord, now just on that point, what has fallen from my lord, the last point, 16(4), my lord, is still part of the...
It is very tough for this court to understand the points which you are making.
The fault would be mine, my lord. In that case, if I can humbly pray, my lord, because I'm slightly unwell also today, let the matter come next week, my lord.
That is a fair thing. You can always take time now.
Obliged.
But then you see the explanation which you are giving,
Because-
is finding is very difficult.
On the last occasion, at least Lordship was with me to the extent that Justice Banerjee's judgment, the earlier round of litigation, his judgment would apply only till the junior grade, my lord.
We understood that part.
Yes, my lord. The
See,
moment...
what basically this court at that point of time
Yes, my lord.
thought correct was that so far as your claim of seniority in the senior grade
Yes, my lord.
is concerned,
Yes, my lord.
that is totally determined
Yes, my lord.
in terms of the list prepared under Order 22 rolled. That is how it is to be maintained. Now the reference of earlier senior list which you have said, this was prepared strictly in terms of that 16.4 after the High Court.
No, my lord.
And that position, the order of the High Court, that over, you say Justice
My lord.
Banerjee's order,
My lord.
was not assailed anymore. So that stands. And it was given effect.
My lord, my lord, my lord.
Now that chapter is over.
My lord.
So for the post where you are appointed, that is over. Now you are on the senior grade.
Yes, my lord.
And in what basis the seniority to be fixed in the senior grade? That is what is to be.
My lord, my lord. My lord, my point...
16.4, the question of coming of 16.4 here doesn't arrive here because you see, like you have not been not been recruited.
Yes,
you
my
see, this is only a promoted thing. Your recruitment was before. Anyway,
yes,
just if you give one thing, if your argument is bit, you say like technical in nature.
My lord.
I will just request, just give a note in writing.
I intend to do that, my lord. I intend.
Sometimes you say one thing, court may not be able to catch it.
I intend to do that. Lordship may give me a week's time also. I'll prepare.
You will get 2 weeks time because 1 week's time next week may not have this.
Very well. Very well.
If I may, Malo, if
Yes.
you can just come to Rule 22, Sub-Rule 3.
Yes.
It also
Rule
says-
22, Sub-Rule 3 is not there.
No, there is no sub-rule 3, I think.
3 is there, Malo.
No. 2 ABC is there. Rule 22.
No,
222 Sub-Rule ABC.
there is no sub-rule 3 in Rule 22. No. No. Huh? No. There is no such rule of 22.3.
You are looking at Meghalaya Civil Service Rules.
Yes, Malo.
In 1975, isn't it?
1975, Malo.
Yeah. No.
The one which I'm having is there, Malo. That is
Please verify that part.
In any event, my lord.
You are holding the one which you have said.
My lord, in any event, I'll file a small written note, and with Lordship's permission, I'll just take 5 or 10.
Make it small. Do not make it thesis.
I won't, my lord. I won't, and I'll also take 5 or 10 more minutes of Lordship's time just to supplement my written submission.
This court becomes nervous if it thinks.
No, absolutely. Even the same is with us, my lord.
Not today. We'll have a floor.
Right.
Just in terms of the order dated, in terms of the last order dated 27/6/2025, stop Mr. Sulai.
You share with us the rule which you have.
Necessary instruction as to the existence of separate list. Other than the notification dated 7/6/2025 prepared by the selection board in terms of Sub-Rule 2 of Rule 22 of the Meghalaya Civil Service Rule 1975. You can get the reference in the earlier orders, just in the last part of the listings. The learned AG submits that there exists no separate list and the notification dated 7/3/2022 is the only list. In terms of subrule 2 of Rule 22, insofar as this case is concerned. Yes, sir. Mr. Jindal. Model counsel appearing for the petitioner. Six, grant of some time to place his argument before this court.
Right.
Prayer allowed, list after 2 weeks.
2 weeks, Your Lordship.
Obliged.
Highly apply, Your Lordship.
6-2.
Yes.
This is this for quashing the FIR and the charge sheet, Your Lordship. Here the settlement has been have compromised, Your Lordship. What happened, Your Lordship? There's a dispute between the boundary of the cemetery of Senkhasi and the village, Your Lordship. Now they have entered to a settlement. They have 30% to the village and the 70% to the Senkhasi cemetery. So that's the ground that because they've entered settlement and the matter is purely civil dispute, Your Lordship. It leads to the land only.
Is private respondent here?
Private respondent is here, Your Lordship.
Yes, ma'am.
Yes. What is your submission here?
I don't have any objection.
Yes. Madam G. You are the main person.
Mr. Gurung is the...
If you say, then we will reject that. If you say no, we will reject the petition.
Senior colleague will answer to that, my lord.
You are not there to say.
No, my lord.
Others you thought will go by what you say.
No, my lord. Sir's submission will be more relevant.
Yes, Mr. Guru.
My lord, basically, my lord, when a compromise is entered into between the parties, my lord, the complainant, my lord, yes, lordship may interfere with it, but kindly look into the compromise, my lord. Firstly, the FIR is being filed by another person, a lady.
Yes.
She is not a party to the compromise, my lord.
No, no, she is page 21, Your Lordship.
I don't know, I didn't notice that.
Page 22, Your Lordship.
Perhaps Mr. Gurung did not get sufficient time to look at that.
My lord. If that be so, my lord, my apologies.
Page
But
22,
that
Lordship.
apart, my lord.
Page 22 at left side. She's the witness number 4.
Page 20.
She is as a witness, my lord.
Page 22.
Yes, Lordship.
No, but then she should be a party, isn't it?
She's a party, Lordship, because this represents as the FIR is filed as a capacity as a assistant secretary of the Senkhasi, Lordship.
See, in criminal case, the responsibility is always personal. Except maybe in company matter something different. But then otherwise...
That apart, my lord.
The law requires
the parties,
the author of the FIR,
exactly,
to be a party in the agreement.
That apart, my lord.
She's also she's present.
The problem is, you know the thing, you may be very confident. For a court doesn't know. See, tomorrow the person may come and say, like, I am not at all a party to the agreement. Then what happens?
The respondent is here.
I'm the respondent before, yeah. And the FIR that I filed on behalf of the whole Senkhasi.
Whatever it is, the fact remains that you were not a party to the agreement. You should have taken care of all those small things. Unnecessary, the complication arises because of things. Probably yesterday also.
Yes, yes, my lord.
Yes,
there was a matter.
Thaba had to withdraw one matter, right?
My lord.
Because of that.
Because of that.
For a charge thing, one person files a file, the another person becomes part of that.
Your Lordship, I'd like to take to the charge the P62, Your Lordship.
Anyway, apart from that, anything else?
Yes, my lord. Apart from that, my lord, to reach into a compromise under 153A, my lord, whether all the issues, my lord, which the complainant had raised in the FIR, my lord, whether that has been resolved. For example, my lord, for instance, in the FIR, the complainant says she was not allowed to attend the meeting, my lord. That apart signboard, my lord.
Yes, again,
yes. My lord, those
You can understand your concern, Mr. Guru.
my lord, those are not in the compromise clauses, my lord. Because in order to, my lord, enter for my lord under 482, quashing 153A, my lord, all the, my lord, prevailing situations in the FIR, my lord, whether that has been permanently resolved. Now that is, the compromise is very silent on that, my lord.
The agreement.
Exactly.
Now, can you take consideration of their submission, which they advance before the court, on behalf of those parties?
Whether, my lord, I don't see any specific authority on behalf of, my lord, the complainant here, my lord. Because I think my learned friend is appearing on behalf of the, my lord, the organization, my lord.
Your Lordship, in the...
And the FIR looks like, my lord, it is personal in nature, my lord.
Yes, it doesn't say on behalf of anything.
It doesn't say, my lord.
It may give an address designation of the party.
Exactly.
But then it doesn't say on behalf
It's
of.
personal in nature, my lord.
So, Your Honor, Lordship, this is purely based on the land dispute of boundaries. So now that that has been resolved, say that
Kindly
I
see
do
the
not
FIR.
have any objection to if this case was.
See, probably, Mr. Gurung, probably this is the second round of litigation. The first round litigation also, there are some defects, and then that was withdrawn with the party to file.
My lord,
I would not like to, you see, relegate them to the same position again and withdraw it and file.
That is true, my lord, but at the same time, my lord, absolutely correct.
If you do not have a very serious objection, then we will proceed. We will just, we'd like to see that matter ends.
7 except, my
With
lord,
this kind of
what my lordship had pointed out just now, my lord. The complainant should not, my lord, come back and say that I was not a party to it, my lord.
That is what
that is the danger part,
That
my
is what
lord.
the dangerous. See, we should take care of that.
Because page 16 also FIR, the complainant estimati Banpre Elmar Banyang Assistant Secretary Senghasi maupun, Lordship.
That is so far as the designation is.
But the contents is personal.
Today, no incumbent here. The court, Judge High Court, writes something as a Judge High Court. Will it bind the entire Meghalaya High Court? It will not, isn't it? Until unless just specifically you say that I filed it on behalf of this. Okay, more so this complaint is not on the letterhead of that organization, isn't it?
My lord.
Anyway, we do not know, you see,
and moreover, Lordship, in this clause 6 of the agreement, you said that part of the Senghasi maupun have mutually agreed and compromised with the village Darbar maupun to remove the case against the headman and the General Secretary of Maupun village pending trial before the district court. No,
Mr. Gurung, but then you started with the thing that you do not have an objection. And
that is true, my lord.
You wanted to point out something.
My lord, I am not against it, my lord. I am not against it, my lord. I am just trying to, my lord, assist the
No, that is,
court, my lord.
your concern is that
Yes, my lord.
it must be a complete settlement, isn't it?
Exactly, my lord.
It should not be just for the purpose of
Exactly.
escaping from the clutches of the.
Otherwise, I am not.
There should be
Exactly.
absolute settlement, isn't it?
Exactly. Firstly, my lord, all the complaints in the FIR that has to be resolved permanently. Secondly, my lord, the author of the FIR, my lord, has to be a party. But here she is a witness, my lord. Let there be a kind of, my lord, an authority from the complainant. Then I don't have any issues, my lord.
That what kind of authority that she is a party? You want that something should be brought in.
Exactly, my lord. Later on, she cannot take a U-turn and then...
You can do one thing. It's okay to be safer in the things that will take care of things. You can just bring on record, file one, give one small one-page affidavit supporting the case. I think that is one that will take care of the things.
Yes, ma'am.
Just one-page thing that you support this petition and that you are a party to the compromise. Okay, and if this matter is settled, if this matter is closed on the basis of settlement, you will not raise any objection.
My lord.
On the party. You know how to draft.
Yes.
You are just saying that what should be taken care of. Because, as has been pointed out by Mr. Gurung, there appears to be some technical things. And this one thing will be, the court will be responsible, court would become responsible if the complainant comes on subsequent stage and says that I am not a party to the complaint.
Understand? Let them file.
So just give one page.
Yes, sir.
Okay. Hard learning counsel for the parties. Stop. Mr. Please give your name, please. This book forgets the name. Your name, please.
GJ no.
JJ Nangpur.
GJ no.
Nangpur. Okay. The learned counsel appearing for the restaurant number 544. Submits that an affidavit on behalf of the said respondent. Submits that an affidavit on said respondent showing her willingness to settle the matter would be filed. Stop. He prays for grant of some time for enabling the restaurant number 4 to file an affidavit. Prayer allowed. List after how long will it take? 2 weeks. You file it in within 1 week, we'll have it after 2 weeks because no problem. We'll have it after 2 weeks.
Obliged.